Good evening, everyone, and welcome to our second year of Rights at Night sessions on Tuesday nights. I am Lisa Morgan, a kindergarten teacher and president of GAE. And this evening, our presenter is Mike McGonigal, GAE General Counsel. And our topic tonight is something that I know many of you have questions about related to your employment, and that is social media and free speech. I know many of you have had concerns about various things in your building, particularly COVID protocols, and especially this year, COVID protocols. And you are wondering, what can I really say? And what can I say on social media and be protected? So that's why we're having this session tonight. And I thank you all for joining us. If you have questions, please put them in the chat, and I will ask the questions as we go through the session. And at this point, I will turn it over to Mr. McGonigal.
Thank you, President Morgan. Good evening, everybody. Let me get my screen share going here. Go. So as President Morgan said, tonight's topic is going to be on free speech, social media, and some implications for you in your status as public school employees. I always want to start because I have a captive audience here and we're all about recruiting members. A reminder of the protections that GA Legal Services has. Liability protection is greater than the competitors. The competitors offer up to $1 million of liability protection. The NEA GAE insurance offers up to $3 million. But we don't see very many lawsuits that require liability protection during the school year. That could be anywhere from 5 to 10 per year, where we see the greater number, the vast majority of cases in legal services is under the employment and certification defense. And that has no predetermined caps on the amount of attorney's fees and costs that we will expend in defense of member rights. We also file affirmative lawsuits, and I'll be getting to a number of those later in the discussion. But many of our cases do exceed predetermined caps that other organizations have. And our affirmative lawsuits are usually pretty expensive, especially considering what your salary and benefits are as a public school educator. So it really does provide you with a great value for your dues dollar. So if you happen to know potential members in your buildings, this is one of the tools that you can use to recruit them and help us join the fight. So just a quick reminder or overview as we get into the discussion. So what are the sources of law? What are the sources of your rights? And I guess my question really here is, what is the one thing that all of these have in common? Your federal statutes, your state statutes, your regulations at the Georgia Department of Education, Professional Standards Commission, and of course your local Board of Education policies. Well, the one thing that really brings them all together is that they are elected officials. And so those that we elect to federal office, state office, and local Board of Educations are going to determine our future. So it's very important that we organize and elect friends of public education to these positions. Again, because this is where your rights are actually created and where they are being taken away and where they're going to be, where they are eroding. Under the last bullet, I would be really, remiss, as they say, if I didn't at least spend just a minute educating on the models of education here in Georgia. There are three: a traditional system, a charter school system, and a strategic waiver system. The idea behind charter school system and strategic waiver is that these school districts, and it's the vast majority in the state, in exchange for waiving your rights, the student achievement will increase. And that is the bargain that nearly every school district in the state has made, except two, which are traditional models. But every other school district in the state has entered into agreements waiving numerous of your rights in exchange for increased student achievement. And we'll have another Rights at Night, I believe, solely devoted to waivers, what they're about. But it's really one of my passions for the past few years, wanting to educate our members about that. So we'll spend the bulk of the time, though, getting into constitutional rights. That's where our free speech rights are from. But of course, one of the, it's an area that can be very murky. And free speech, particularly in the public school, public employment realm, is certainly not absolute. And the First Amendment is a wonderful tool that's still alive, but we have to keep in mind it doesn't give us the right to say whatever we want, to whom we want, and just say whatever we want, particularly when we are in the classroom on the school time. We have more freedoms outside the classroom, and we'll get into what those are. And of course, the First Amendment has other freedoms like religion, where we're entitled to express our own religious views, but it's certainly not in the public employment context. There's a separation between church and state there. And of course, the right of the press, they're the fourth estate. They're there to keep government honest and keep asking our elected officials probing questions, and then have a right to publicize their findings and stimulate public debate. Right of association, that is often used in our lawsuits when we're filing against districts that have violated our members' free speech rights, but we often always incorporate the associational rights. They are members of GAE and a local association. That is specifically protected in the First Amendment as well, right of association. And then there's a right of petition. There's not a lot of litigation on that, but we do, for example, we have rights to sign petitions. For example, if we're unhappy with a school board or a superintendent's ruling, we, in your status as citizens, have every right to sign petitions for redress against your school board, for example, or a right to say a recall petition. If you want to recall locally elected officials, you do have that right, and you do have the right against retaliation for signing that petition. So getting into, it's actually a discussion of where we have our strongest protections and where we really don't. The First Amendment protects speech of public employees only to the extent that we are speaking as a private citizen on a matter of public concern. Now, you can ask yourself, when you're in the classroom doing your job, whether it's teaching, you're an administrator, you're a custodian, you're working in the kitchen, you're a public employee, and it's extremely hard, if not impossible, to carve out situations when you're at school that you're acting in your status as a private citizen. So it's extremely difficult to find a fact situation where that really can occur. You can speak as a private citizen on matters of public concern, most definitely off the clock, on your own time, on the weekend, at night, all of those things. But it's important, if you look at the second bullet, it seems to me the most important things we can do to protect ourselves if we're going to the school board, for example, and we want to talk about class size or the lack of class size limitations and how that's detrimental to teaching, how it really doesn't lead to student achievement, although the school district has waived class size limitations. You want to get up and address the board as a citizen, as a taxpayer, a voter, a parent, an aunt and uncle. You want to use your additional legal statuses, and you don't even have to mention that you're a school employee. In fact, oftentimes that's a better strategy if you're speaking in front of a local board. And the same advice would go for if you're posting on Facebook, discussing matters of public concern, such as class size, lack of duty-free lunch, waiving your fair dismissal rights, or the COVID conditions and protections that are there or not there in your work environment. Utilize your local association. That is what makes us so unique and so different from other organizations. And we are constantly looking for leaders in our locals who are going to help us build capacity. As we all know, in a union environment, we are stronger together, and there's power in numbers. So we need to utilize our local strength, because most of your most important rights are not just the First Amendment, but they're also created at the local board level. Extremely important that we organize at the local level and speak before the board, petition the board, and speak as a collective. It doesn't make much sense to me why one person is wanting to effectuate systemic change. One person is important, but we have so much power if we work collectively. And we're up against a lot of systemic issues, always have been. So one of the reasons we are members is that we are associated, and especially at the local level. Also important, since we're all about obtaining power, is that we utilize our relationships with community groups, our churches, our parent-teacher organizations, local chamber of commerce. You can find common ground with the local chamber of commerce. I think one of the issues about class size, I think most people would agree that waiving class size limitation doesn't make any sense. And there is data out there through academic studies that shows that smaller class size does lead to better learning and higher student achievement. So where public employee speech is not protected, and the first one is kind of hard at first for me and a lot of lawyers to wrap your head around. But if your speech is spoken pursuant to your job duty as a teacher, as a public employee, the US Supreme Court came out with this terrible decision in 2006, Garcetti versus Ceballos. That case was about an assistant district attorney out in Los Angeles who was blowing the whistle on a ticket fixing scheme in the police department out there in Los Angeles. And he got fired because of it. And the district attorney didn't make any bones about it. And of course, he sued, saying that he had a free speech right to uncover this price fixing scheme. the firing was wrongful. It was illegal. It was unconstitutional. Makes perfect sense, except when it reached the United States Supreme Court, and they came up with a rule and said that that district attorney actually had a duty as an assistant district attorney to report and blow the whistle on the price ticket fixing scheme that the local police officers were running out there. And because it was his duty to do so, they said, you do not have any constitutional protections under the federal law. You must look to your state constitution and any state whistleblower law that you might have available to you. But no longer does the federal constitution protect public employees such as yourselves if your speech is arising out of a duty in your job. So for example, you have a duty to report child abuse. And if you're fired or retaliated against for reporting child abuse or child neglect, which you should be doing, the courts are saying the First Amendment under the federal Constitution will not protect you. We will, and we have been very successful in court, however, under state whistleblower protection when special needs educators have reported child abuse and child neglect in several school systems around the state. And we look at the Americans with Disabilities Act, advocating on behalf of disabled children, and there's also anti-retaliation protection under the IDEA. We have to look at those protections as well as the state whistleblower law. So there are those protections. If your speech will not be protected if your speech deals with personal or personnel matters. So if I'm in the principal's office and I'm having a heated argument with my principal about my TEKS evaluation, and I raise my voice and I here's my TEKS and decide to tear it in half and throw it down and walk out. Courts have said, and this is basically a literal case out of Georgia a number of years ago, teacher did that and sued, saying that she had a First Amendment right to express her opinion over her personnel evaluation. The court ruled, well, no, you don't. That is not a matter of public concern. The public doesn't care about Mike and his teacher evaluation. The public might care about, eliminating class size, for example. And if I'm speaking in front of the local board, we have greater protection there. Or if your speech, even off-duty speech, on a matter of public concern causes a disruption in the workplace. And it's a disruption in the workplace, and we'll get to that. The Atwater case, classic example of what not to do. The last place where your speech wouldn't be protected if you say something that is untrue, like a false fact. Like if somebody says, Mike's a bad lawyer. Mike's a bad lawyer, doesn't do his job, he doesn't work. That might be a matter of opinion, and opinion is protected. If somebody said Mike is a convicted drug dealer, that's a false fact, because I can prove with evidence that my criminal background history has nothing on it. And if I suffer damages as a result of that publication of a false fact, I would have a valid claim against that individual. Well, let's look at a case where an educator in Tift County exercised her right to speak publicly about the Black Lives Matter. It wasn't really a protest, it was just a march. And it was during the holiday period in, I want to say 2015, 2016 in Tifton. And it was covered by local radio, local media extensively down there. And the educator went on her Facebook and said some fairly offensive and disruptive things about the protesters. For example, this educator on her Facebook said, "It's turned into a race matter." It meaning, I'm not exactly sure what it is, but it's turned into a race matter. She goes on to say, "What about the thugs that beat the father in his vehicle because he didn't slow down? And what about the thugs that shot the college baseball player because they were poor? If the dude hadn't stolen the car, he would still be alive. I think the protest sign should read, 'Take the hood off your head, pull up your dang pants, and quit impregnating everybody.'" Now, clearly that was a matter of, it was her opinion on a matter of public concern. But can you imagine the effect that speech had on the students in Miss Tucker's middle school class? She was teaching at Tift County Middle. Can you imagine the effect on the students? Can you imagine the effect on the parents? And can you imagine the effect on the superintendent's office when this was publicized? Because they blew up the superintendent's phone, obviously. Well, so she only received a suspension of 5 days in diversity training, but she found some lawyers, it's not a GAE case, and sued for this discipline for off-duty speech on a matter of public concern. And the court ruled, as they should, that it caused a disruption in the workplace. It really did. It really harmed the kids, the students, harmed the parents, and proved very disruptive. So she did not prevail in that particular lawsuit. So we'll go through some scenarios. Do you want to take questions now or when?
So far we don't have questions.
Don't have, okay, great. Feel free to ask questions. Well, so let's go through some scenarios here. So you participate in a weekend rally protesting police brutality. Would that be protected activity as a public school employee? Anybody want to guess the answer?
I'm going to say yes.
You are right. You are right. You're perfectly legal. It's perfectly legal for you, even as a public employee, to do what you want to do on the weekend. A protest march is a legal activity. And so there's plenty of examples of educators participating in various protests in the past few years. And that is constitutionally protected activity. So number two, you post on your Facebook wall a local newspaper article favorable to a political candidate. Well, how is that any different than having a yard sign in your yard, for example? You have every right on your own time to, say what you want about a political candidate. And the school district cannot retaliate against you. Now, there is some court authority about wearing political buttons and I am for candidate, Joe, or I'm for candidate Mary, and wear a button. Those are prohibited in the school because you're supposed to be neutral. And when you're on the clock in the school, courts are saying you are speaking for the school. So courts have ruled against wearing buttons and t-shirts in the school, at school, but what you do on your own time is generally protected, unless, of course, it's going to cause a disruption in the school.
Okay, I have a question about that.
Okay.
Because I've seen people doing this where they put a political sign in the window of their car. And then, of course, they drive to work. Is that going to be okay, or should they take it down while they're there?
I haven't heard of any court rulings on that, or what about a bumper sticker?
Yeah.
Same thing. So in my view, bumper stickers and signs in your rear window, things like that, they should be okay. I think where the problem comes in is when you cross over and get into the actual building, and now you're mingling with impressionable students and all that stuff. So I think that should be fine. Let's see. Number 3, you write a letter to a publication that's critical of the school board for one of its actions or ideas. Well, again, that would be completely legal and constitutional as long as the criticism affects all taxpayers or affects a district-wide policy, not something that affects me individually in terms of, say, a personnel matter. But if you write a letter that's critical of the board, say lack of COVID protection, or you've waived my fair dismissal rights, or those sorts of things that affect all tax-paying citizens, say in DeKalb County or Dooley County or Walker County or Catoosa County, that's going to be fine. That's going to be completely protected. So number 4, you post a joke on Facebook that your students should be locked up. President Morgan, what do you say about that?
No.
It's no.
Not okay.
No, not okay. No, not okay. You'd be surprised though what some educators would post thinking it's funny. But remember, what I think is funny may not be so funny to the listener, or the impact that has, my funny joke, is going to have on the audience. So in a court is not going to look at my subjective intent as much as they're going to look at the impact on the listener or the hearer or the audience, whether it's a verbal statement or an email or a Facebook blog or something that you tweet. Number 5, you're instructed not to discuss with students your personal opinion on political matters. You're instructed not to discuss personal opinions on political matters. So with that, in a classroom discussion on racial issues in America, you tell your students that you recently participated in the Black Lives Matter demonstration. That is potentially risky because you've been advised and told not to discuss your personal opinions on political matters. So that would be risky. There are some courts that would uphold discipline in those situations. It would be a different outcome if you weren't specifically told not to discuss your personal political views in the classroom. That's going to be a whole separate discussion about what's happening out there now on critical race theory. The things to keep in mind there are that it's the discussion on critical race theory is really a political ploy to stir up a certain segment of voters. Our focus is and has been on teaching honesty in education, and when we teach facts that may be uncomfortable, as long as they're related to the curriculum, that's going to be fine. And some topics by their nature are just going to be controversial no matter what they are. It could be a math class, it could be an English class, it could be any number of things. So as long as we're teaching honest history, it's related to the topics in the curriculum, we're going to get through this in terms of what we're doing in the classroom. The larger question is the political answer. which is registering people to vote and getting people to the polls so that we can put a stop to some of this, seems to me, attempts at censoring classroom and what we do in a classroom each and every day. So.
You have a question?
Okay.
Okay, so many of us work in charter systems who have waived our fair dismissal rights. How concerned should we be that exercising our protected speech under examples 1, 2, and 3, while not resulting in termination or direct disciplinary action, might still result in a non-renewal in the spring?
Right. It's going to be really dependent on facts. A classic retaliation case is going to be that the educator, if they're a classroom educator or a custodian, they had a very good performance record up to the point where they expressed their opinions, on the weekend, off the clock, at a rally, whatever. And after there's that speech or that behavior or that conduct, that protected speech, the employees' evaluations go down the tubes, then we're able to demonstrate a cause and effect. Whether or not you have fair dismissal rights, you can be an at-will employee like a paraeducator or a custodian or a cook, or a bus driver. And there's a case coming up where we had a bus driver get fired or demoted, I should say, for her recruiting activities. We sued and won that particular case. So fair dismissal, extremely important. One of my passions is to get that restored, but that you still have the protections regardless of fair dismissal. But I would strongly urge locals where it's been waived, we need to build a groundswell of support amongst the community to educate them that the waivers aren't working. They're supposed to increase student achievement. The Georgia Department of Audits conducted an audit in 2019, I believe, and there's no data to support that these waivers work. So, but what you should know, you asked the question, you should know that GAE and NEA has your back. That is one of the reasons why we are having this discussion tonight, so that our members will feel comfortable and confident in participating in organizing activities at the local or state levels. So let me, yeah, we got to read your local policies. You should all look at, your school board website, look up, do you have a social media policy? You may not. It used to be you had an acceptable use policy on the do's and the don'ts of using the school district's technology. Some districts have social media policies, others don't. But it's important that you look at them. I saw one a number of years ago, a proposal in Clark County that said, I can't remember it all, but one of the things that stands out, what I remember, is it said that employees of Clark County schools could not be friends with students. Well, that doesn't make any sense, because I might have a son or a daughter or a cousin enrolled in Clark County, or they might be enrolled in, Timbuktu. And so the policy as written, it was overbroad and unconstitutional. And we stepped in, wrote the district a letter about the constitutional problems that their proposal had. And so they withdrew it. They said, okay, you made your point and we're backing down. So read your policy. If you have questions about it, contact your UniServe director, contact legal services, and let us have a look at it if you have questions. Things you probably know, when you post something on Facebook, it's going to be there forever. No such thing as hidden from public view. Don't use a school computer, or probably don't have too many people with school phones, but don't use those for personal business. It's all there, whether you think it's deleted or not. We work very hard at legal services in some of our legal cases that we have ongoing, and we are going after text messages of school board members and superintendents and those folks in the central office that may have information about the, whatever it is we're pursuing. And we hire, through our program, we will hire computer forensic experts. We will get those cell phones and we will download the information, we'll conduct searches, and we will find, whether it's deleted or not, we will find oftentimes people are not very careful. Surprise, surprise. So those things are there. Again, NEAGA Legal Services, if you find yourself on the receiving end of retaliation, we have ways of getting at that information. That stuff was just sitting there. And people are not that smart. So let's get into some of these cases that we have done over the years. The first one, I just chose this one. One of our members in Walker County wanted to get on the board agenda to talk about the grading policy in Walker County. And the Walker County policy said that any employee or citizen that wanted to speak to the board had to first come and talk to the superintendent in person. Well, that can be intimidating right away, can't it? The policy then said, after they had the conversation about what they wanted to speak on, the superintendent was allowed to investigate whether or not the superintendent was going to permit the employee or citizen to talk to the school board. Well, I'm kind of laughing, but after we worked with this member behind the scenes and got things ready, we filed the lawsuit up there in Rome Federal District Court. And the court said the policy as it is written on paper is unconstitutional. And as it was applied to this member, it was unconstitutional. And that case went on. They appealed it. They lost terribly at the trial court. School board decided to appeal it to the 11th Circuit Court of Appeals. And, you don't want to say that's good. It's really not, because it's a waste of taxpayers' money. But we have an excellent decision that is now within the federal circuit around the country. And in that particular case, you can see how expensive this particular case was. I don't have $330,000, President Morgan, do you?
No,
No.
I don't.
Okay. Here's the case. A kind of an older case from Gwinnett, where our local president at the time had been speaking in front of the school board, speaking out her concerns. And the school board eventually decided to take away payroll deduction because they said the administrative costs were too expensive. Well, it was pretty apparent that the reason they went after GCAE, the Gwinnett County Association of Educators, was really about the local president speaking up about matters of public concern that affected all the school employees in Gwinnett. And they didn't go after her. They took away payroll deduction. And so on the basis of that, we filed a suit and won. I mean, there was really no question about it. And in fact, in the discovery, there was a letter that was found that the superintendent at the time, Mr. Alton Cruz, wrote about the situation that he and the school board threw a few hardballs at GCAE, and the members who voted against taking away payroll deduction, they testified the real reason for taking away payroll deduction was to destroy the local association. So we prevailed, payroll deduction was restored, and the rest is history. So here's the bus driver case. Elizabeth Cook, bus driver in Gwinnett County, very active a number of years ago. She was recruiting members during the layover period. You know, when bus drivers have, layover, they have downtime, and she was talking up the local association, talking up GA and NEA, and word would get around to the transportation officials, and they told her how awful we were, that we were much like a union, and they didn't like the union activity in Gwinnett County. They also, the local Ms. Cook and other members there, participated in handing out flyers about raising money for community groups, and food drives, things of that nature, as well as talking up some of the working conditions there, particularly around the bus barn area that was not paved. It was mostly gravel. And so when it was, really, really dry times, buses coming in and out of there and vehicles kicking up all this dust and people are breathing it in. Well, that was one of the issues that she brought to their attention. So she was demoted from her position as a team leader, which meant lost income and lost prestige. And again, we sued in federal district court and eventually prevailed under the First Amendment. Her activities were completely lawful under the Constitution. And in that particular case, I don't know what the legal fees were, but I know that Ms. Cook received a check of $100,000 for her damages. So what we're doing now in Gwinnett County, we're on a roll in Gwinnett. This one is kind of takes your breath away, I think. Jeff Corkle is a GA member, and he participated in a protest of the way Washington was treating immigrants at the border. And so he was at a protest in downtown Atlanta at the ICE headquarters, and he was arrested. And this is all caught on local TV. He was arrested, booked the whole 9 yards. The charges were dropped. Everything was fine, except, I hope you're reading the slide here. His TEKS evaluation was affected. The principal of Mr. Corkle's principal wrote in his TEKS evaluation, this conduct, meaning his protest on a weekend, is contrary to our community school standards and jeopardizes the character and reputation of our school, community, and profession. These actions are contrary to the expectations of professionalism. And he wrote that in his TEKS. Well, when it got to my department, we asked that it be removed, and they did not do so. We reached out to their school board lawyer saying, hey, this seems to be illegal. Why don't you just fix the problem? And when they didn't, we filed a lawsuit, and that case is still chugging along. But that's one of the benefits of, again, GAE. Something like that is just atrocious. You can't put that in your TEKS evaluation and expect to get away with it. So I think our last one, Linda Wolf Smith was outspoken president of the Atlanta Association of Educators for a number of years. And at a certain point, Linda wanted to retire. She put in her papers and then discovered she wanted to rescind them because she was at like 29.999 years and she wanted that extra month, which anybody, you can't blame her. But they said no, they didn't allow her to rescind those resignation papers. And we know how Atlanta, well, I shouldn't single them out, I suppose, but we know how it works. And we ended up filing a lawsuit against them. And in the discovery phase of the litigation, we had plenty of examples where the school system allowed people to take back their retirement applications, or if they put in a resignation, were allowed to rescind the resignation. The only difference between those folks and Linda Wolf-Smith is that Linda Wolf-Smith would get up in front of the school board and advocate. Lack of textbooks, I mean, on and on and on. Low salary, class size, overcrowded classes, on and on and on. So the only difference that distinguished her from the others is that she was speaking at school board meetings on matters of public concern, constitutionally protected rights. So that's our last example of what we can do as an organization. And hopefully these cases will also help bring out the right way to speak, the constitutionally protected ways of speaking, even though you're a public school employee. So that's it. We're in this together. We're stronger together, and we're here to support our members. If we have any questions or anything else you'd like to talk about, President Morgan, we've got a few minutes. So.
Yes. Okay. So if anyone else has a question, please put it in the chat. I think my question is, and this is a concern I hear from educators all the time. You know, if I say something, if I post on Facebook, or if I talk to somebody and tell them what's happening in my school, I'm going to be retaliated against in my building. What do we tell them? And then the next question, and this happens a lot currently for me, reporters will contact me and ask me for a teacher that they can talk to. And of course, I'm always referring them to a member. And I say to the member, identify yourself as a member of GAE. But if they do that, are they protected?
Yeah, short answer, yes. They have the right of association. The first question, again, the level of protection depends on what it is you're talking about. If you're talking about the mold growing all over the school, not just Mike's room, but all over, that's going to be a matter of public concern. Remember, you need to pick a topic that all taxpayers of DeKalb or Dooley or Chatham are going to be concerned about. Mold in an entire school is going to be something that's not really affecting me personally, even though it does. I want to broaden the context out. And I'd want to say I'm also speaking as a citizen taxpayer. My taxpayer money is going to this moldy school that's harmful to our children. And you can think of examples during the pandemic as well. The lack of protections for the children. You want to put the kids out in front, not necessarily me. You want to say how it's affecting the entire school and the children. I mean, it's important. It's important for moral reasons, and it's important for legal reasons, that when we speak about conditions at the school, that we are talking about the community, not just an individual, but the community. And I think the more we emphasize that, we're doing the legal thing and the morally right thing to do as well.
Our next question is not directly related to this, but it can be. What happens if you get COVID? And why do we need to use sick leave? And what can we do about it? And one of the things we did a lot last year talking about FFCRA and the COVID leave in there.
Yeah.
But those provisions have expired.
Mhm.
So yes, districts are saying you must use your sick leave if you get COVID or if they ask you to quarantine. Work with your local once again, because districts can use the American Rescue Plan funds to provide you with COVID leave. But that's something that you are going to have to work with your local school board for them to provide that. And again, if you go one person speaking to the school board, they're going to say, they're going to sit and listen and smile at you. But if you have the community behind you and a lot of people to speak to the school board, then you're more likely to get something happening about that.
I completely agree. It's who we elect, and the FFCRA mandate paid leave for COVID related leave that expired December 31st. And for whatever reason, current administration, current Congress made it discretionary. So President Morgan is right that you have to work with your local board of education to provide some salary protection, some benefit protection in a pandemic crisis.
And one thing I will let those of you who are watching know, the local districts are right now completing their applications for how they are going to use those ARP funds. So check your messages as a community member, see if your local district is accepting input with that. And they asked if GAE can help with that. And yes, we can help your local with the legal and that, but we can't be the ones to go to the school board. It's gonna have to be your local president. I'll be happy to go to your local school board, but they're gonna listen to your local president and the members in your local and the parents in your local, because unless you are in Gwinnett, I don't live there, so I don't pay taxes there. So that's where we are with that. And if anyone else has a question, we'll give you a couple of moments to stick it in the chat. And while they are, I'm going to thank you all for joining us again this evening. And I'll do a little commercial next month on September, let me get the right date. September 28th will be our next Rights at Night session, and we will be talking about teacher keys that evening and evaluations and what it's going to look like this year. And then we have events scheduled in October. We will be talking about the waivers, and then November we'll be talking about the legislature.
Excuse me, Lisa, I have one question. This is Miss Kulkarni.
Yes, ma'am.
Mr. McGonigal was talking about mold, and if there is a mold in the school in particular room and the principal is asking you to move in that room, what should we do?
The principal is asking you to move to a mold infested room?
Yes.
You should, you would have to follow the directive or face insubordination. I think that you would have to get the school to prove that it was safe. You can request those things. You can have a study done. You can request a study. It's better if you do that through your local association. You can file a grievance over it. You can say that's a unreasonable work environment, and that it wouldn't be insubordination. In other words, if you refuse to go into an environment that was not healthy to you, if it places you in an unreasonable health risk. Now, if you choose that course of action, you're going to have that backed up with medical opinion. You definitely need to, I say, medicalize a situation like that. Go to your doctor and have him or her write up a request for an accommodation, that you not be placed in a non-moldy classroom, if you will. In some situations, I've seen where remediation efforts have to be attempted. For example, if the carpeting is molding, and if that is the source of the moisture and the humidity, it's in the carpeting, they may have to take the carpeting out, or they may have to purchase dehumidifiers for you. If you're going to go in that environment, they would have to purchase you the dehumidifier for the room, or install special filters that the building may not have. So those are the alternatives that you can explore if you are.
But what about, excuse me, but what about you, DeKalb County School has already given you ADE, has labeled you as you are having a disability. Then what do you do?
I think, Joy, you're going to need to talk to the UniServe director, because you're going to want to get all of this documented and get everything documented, and they're going to be the ones that can help you with your specific situation, because it's going to be different for different people. What we're talking about tonight is trying to be general for everybody.
Yes.
But always contact your UniServe director, because they are the ones that are there to help you with those kind of issues.
Yes, thank you.
Okay, thank you.
Thank you.
And I want to thank you all for joining us this evening. And I will remind you, next Wednesday, September 1st, next Wednesday, we will be doing Facebook Live. And Joe sent me a message to remind me that we will be talking about the new parental leave that all public school employees are eligible for. And we will also be discussing the COVID leave and the options there. So join us on the GAE President's Facebook page next Wednesday at 6:30. And I want to again thank you, Mike, for doing Rights at Night with us. I learned something every single time, and I know our members that have joined us did as well. And I thank you all for joining us, and we will see you next time.